Well, hey everybody, welcome. Glad to have you with us. My name, for those of you who don't know me, this is Jackson Mummy at Celebration Bar Review, and we're glad to have you for today's discussion on Facebook Live, and then hopefully later on a podcast of the recap of Supreme Court decisions, not just in Florida, but across the whole country from the recently completed term. And by recently completed, I mean like a few minutes ago. So I'm still, rapidly flipping through pages and trying to make sure I've got the things that I need to have here. What I want to do today is to go through what I think are some significant cases that I think may have some impact on the bar potentially, or at least that you might be wondering about. I'm certainly not going to try and cover them in detail or talk about everything that's happened. I'm also going to try and avoid talking a whole lot about the politics of all this, although it's almost inevitable, I think, given the current nature of the court. Now, for those of you that are on the Facebook Live presentation, if you have questions about what I'm saying about these cases, feel free to type them in on your Facebook browser or whatever you're using, and I'll try and get to them if I can. If you're listening to the podcast or you're watching this later, feel free to comment later on Facebook or to send an email or comment on the podcast, and we'll try and reply to all of those. Again, if you're not familiar with what the Supreme Court has been doing, it's been a very interesting term. The term ended today. Typically the last Monday in June is usually the last day to announce decisions, and that's what occurred today. So we've now got the entire term of decisions in. The speculation will begin immediately to start talking about what the impact of a ninth justice may or may not have on next term and the cases that they're accepting. So let's jump in by talking first about a couple of cases that were decided fairly recently that I think have some implication for the bar exam. And as I talk about what happens on the bar, I think it's important to preface all of that by saying that the bar exam that all of you are going to be taking in July, those of you that are July 2016 bar takers, your test is written. It's in the can. It's done. And so if there is a connection between a multiple choice question or an essay question or a performance test and the real world, it's purely coincidence, and somewhere there's a bar examiner who's having a very bad day if they decided to write a question on some of these topics, because frankly it means that any answer is probably acceptable, and that's not what the examiners want. They want clearly defined rules of law. So we're going to get to a couple of things. Let me just give you a spoiler alert. Even though there was a huge decision in Texas today regarding the abortion case, I'd be very, very surprised if we see anything on the bar exam around that topic at all. But we'll talk about the case a little bit anyway. Okay, so with that in mind, let's jump in. And the first case that I want to talk about, and I guess I got to say this too, you don't need to be able to cite case names on the bar exam. Sometimes people ask me this. I'm just going to tell you the case names so you can look them up and find out a little bit more about them, but really you don't need to know them. But the first case I want to talk about is Birchfield versus North Dakota. And Birchfield was decided last week, and it's a fairly interesting case for the bar exam because it has to do with the constitutionality of requiring DUI drivers that have been stopped on potential DUI, to take a breath test or a blood test, and whether or not a warrant is required, and whether or not you have to have, is it a criminal statute or not. Now, there were essentially laws in a number of states, I think 12 states, that imposed criminal penalties on a suspected drunk driver who refused to take a breath test. That's when you literally breathe into the piece of equipment, I'm told, to measure the alcohol in your bodies. So what happened is that in this particular case, and again, we only had 8 justices deciding, but 6 of the court's 8 justices agreed that those laws do not violate the Fourth Amendment's ban on an unreasonable search and seizure. So a breath test is still constitutional, particularly where it is backed up with a criminal statute. So perfectly okay to do that. But here's where the case got really kind of weird. 7 of the justices went on to say that laws that impose criminal penalties for failing to take a blood test, those violate the Constitution. So, breath test, okay. Blood test, not okay. You need a warrant. And I think that that's significant on the bar exam because there are a lot of fact patterns in which we get suspected DUIs that occur, and there's a breath test or there is a blood test potentially. So the distinction I think that you want to be aware of is that if the police officer administers a breath test and the suspect refuses to take it, that situation, they would be subject to a criminal penalty typically in those 12 states at least, and therefore that penalty is still valid constitutionally. Now, under a long line of Supreme Court cases, the court has said repeatedly that alcohol testing is clearly a search for the purposes of the Fourth Amendment. However, they've also said a search without a warrant doesn't violate the Fourth Amendment if it falls within one of a number of exceptions. And for many years, the police have had the authority to conduct a search of a person that they're arresting. But there's been what they said was no definitive guidance from the era in which the Constitution was drafted, like that really should matter, but apparently it does, that sheds any light on whether the Founding Fathers, who didn't know anything about blood tests or breath tests, would have allowed those to be acceptable for a drunk driver. And for those of you that are constitutionalists and original intent, I mean, this to me is the real epitome of ridiculousness. I don't know. I mean, we didn't have breath tests and blood tests in the 1700s, so what are we supposed to do with it? You tell me. In any event, without that guidance, as though the Founding Fathers would come in and whisper into the justices' ears, the court ruled a couple of years ago, when they were doing the cell phone case, that courts should instead look to the extent to which the search intrudes on the privacy of the person who's being arrested, as well as balancing against legitimate governmental interests. And that's the test that you want to look at. So, using that test, their own precedent, the court in this case said that the balance weighs in favor of allowing the search without a warrant, because there's no real physical intrusion when you do a breath test, and therefore, and they said it's just the same as blowing up a party balloon. Yeah, with a little different consequences, but okay. So breath tests only tell you about the concentration of alcohol in the driver's breath, and that's all that they do. But now, if you, and the legitimate government interest here, obviously, is we want to keep drunk drivers off the road, and we don't want to swamp the local courts, for a warrant every time we stop a driver. So it really would be burdensome, the court said, to require a warrant for those kind of breath tests. But then, in contrast, as I said, the court concluded that blood tests don't pass constitutional muster. While they're very important to stop drunk driving, they are significantly more intrusive. And if you're needle phobic like I am, you'd only say, duh, absolutely more intrusive than breath tests. You have to pierce the skin, and well, I'm just not going to go beyond that. You get the idea. Now, there are some interesting sort of extensions of that. Justice Sotomayor talked about she would have ruled that breath tests also require a warrant, and Justice Ginsburg said the same. I suppose this won't surprise anyone that Justice Thomas said, oh, no, there should never be a requirement for a warrant. We should just be able to do whatever we want, whenever we want. Police officer who thinks someone's intoxicated, no warrants needed to test them any way they want. Thank you, Justice Thomas, for that enlightened view of the world. In any event, the court sort of struck the middle ground, said breath tests okay, blood tests not. So if you see that fact pattern in a multi-state question or in an essay, that's the rule that you want to use. Breath tests okay, no warrants needed. Blood test, you got to get a warrant. So that's the key. And I think you might see that because it is a very common fact pattern. And again, the examiners would have written this question long before this decision. If they went that direction, now they're kind of stuck. There's not a whole lot you can see. The other part to be clear on here is whether or not there's a criminal liability statute behind it. So this ruling applied to 12 states where there was already a criminal statute for failing the test. I think what you're going to see is a whole lot of other states that hadn't had those criminal statutes are now going to rush to pass them so that they can get under the constitutional framework for this problem. All right, well, while we're talking about police and stops, I guess we need to go to a case that totally makes me crazy. It's Utah versus Strieff. And I don't even know where to start. This is a Fourth Amendment search case that says that police can use evidence of a crime in court from a admittedly unconstitutional search if they find, get this, because this is not what you're expecting, you can use what you find from your unconstitutional search if the suspect has one or more outstanding warrants. What? frankly, if you don't do anything else, and I know you're all busy studying for the bar, but when you get a chance, maybe after the bar, go read Justice Sotomayor's dissent. It is a classic. I suspect it's one they'll be teaching in law schools for years later, and I'm going to quote it in a little bit in a moment here to just tell you about it. I think she's absolutely insightful about this particular decision. It's a crazy, crazy decision to me. Nonetheless, here's what happened. So here's the fact pattern. An anonymous source called the South Salt Lake Police Drug Tip Line, to report a narcotics activity at a home. There's a detective watching the home, and he observes visitors when he sees Streiff exit the house. The detective detains Streiff, identifies himself as a detective, and questions Streiff before he realizes that Streiff has an outstanding warrant for, get this, a traffic violation. Maybe it's a breath test, who knows? Anyway, now the detective searches Streiff for the arrest, and he discovers meth and a drug pipe. Okay. Now, Streiff challenges the arrest and moves to suppress the evidence found, saying, look, the officer lacked reasonable suspicion. The drugs were derived from an unlawful investigatory stop. And until this case, I think most people would have said that's probably true. That's a Fourth Amendment violation. Well, in any event, the court took it all the way up to the Supreme Court, and they said, the Supreme Court, in a 5-3 decision, that while the officer's decision to initiate the stop was mistaken, his conduct thereafter was lawful. You want to bet? You want to guess who wrote this decision for the majority? Yep, Justice Thomas. The officer's decision to run the warrant check was just a negligibly burdensome precaution for officer safety. Okay. And then Justice Thomas went on, evidence is admissible when the connection between unconstitutional police conduct and the evidence is remote or has been interrupted by some intervening circumstance. Well, that sent Justices Sotomayor, Kagan, and Ginsburg into a complete frenzy because they said, and I think they're right, that this ruling allows the police to stop anyone that they think may have an outstanding arrest warrant. It's going to be okay. So here's what Justice Sotomayor said. The case allows the police to stop you on the street, demand your ID, check for outstanding traffic warrants, even if you've done nothing wrong. If the officer discovers a warrant for a fine you forgot to pay, courts will now excuse the illegal stop and will admit into evidence anything the officer happens to find by searching you after arresting you on the warrant. By legitimizing conduct that produces this situation, double consciousness, the case tells everyone, white and black, guilty and innocent, that an officer can verify your legal status at any time. It says your body is subject to invasion while the courts excuse the violation of your rights. It implies you are not a citizen of a democracy, but the subject of a cartel state just waiting to be cataloged. Woo! Pretty strong words. Okay. Now, part of the problem here, of course, is that I don't think you have to be terribly perceptive to recognize that people of color are disproportionate victims of this type of scrutiny. And so in this situation, an officer could stop a person of color, ask them what they're doing, run a background check for a warrant. If they happen to have a traffic violation or any kind of violation, then they can search them and search their body. So now we've got these searches that are constitutional. And both Justices Kagan and Sotomayor referred to the town of Ferguson, Missouri, which many of you are familiar with. In a population of 21,000 people, they said 16,000 people had outstanding warrants against them. Wow. Okay. Justice Thomas, for the majority, said that no, there won't be any racial profiling. That certainly won't happen. And it's unlikely, he said, that the police would engage in dragnet searches if the exclusionary rule is not applied. Okay, so what does that mean for the purposes of the bar exam? Well, I think if you've got a Fourth Amendment problem and it looks like the police have stopped somebody for any reason, really, all you need to add to your answer is that if they then go check for any outstanding warrants, it's going to be a constitutional stop and not a violation of the Fourth Amendment. And that's all that has to happen. So if they stop for running a red light, or stop for going 5 miles over the speed limit, or stop because they're walking down the street while they're Hispanic or black or whatever, or Muslim, that theoretically then the police can run a background check, a warrant check. If there's a warrant somewhere in your history, then you're subject to search. So if you're asking me where the Fourth Amendment is, I don't know. I mean, and I'm not trying to be political, I just really don't know. And on the bar exam, I think that that means that you should take a very narrow view of the Fourth Amendment. Certainly on an essay, I would be very clear that the Fourth Amendment, it looks like the police can do virtually anything right now. It would take an extraordinary, outrageous fact pattern to be so weird that you say, oh, that's way beyond the pale. And even then, I'm not sure it would be. So just be careful of that. On the multi-state, it's a little more nuanced, I think, because now you're looking at one answer choice versus three other answer choices, and you're just going to do the best you can between those four answer choices. Will you get the right answer? Well, no, because I don't think a lot of people saw Streiff coming this way, and so I don't think the bar examiners would have written a Fourth Amendment question that made an answer choice. Yes, it's constitutional if you search for outstanding warrants. But you may have an answer choice that would seem to indicate that the police are justified in stopping someone if they find some activity or some reason to believe that the person they're stopping might have engaged in criminal activity. This would certainly be one application of that. So those are two Fourth Amendment cases that you kind of got to shake your head and say, I don't know what any of that means, but for the bar exam, I think it means wow. So there you go. All right, so moving on. The next case I want to talk about, which was just decided this week, was or last week, was the affirmative action case in Texas. And the reason I want to talk about this case, which was Fisher v. University of Texas, is that affirmative action is something that we see tested in the bar. There have been, over the years, a number of essay questions, not always based on racial preference, but sometimes gender, sometimes some other identifying characteristic. And so this whole area of affirmative action in college admissions or school admissions has been an area of frequent testing. And frankly, the court has kind of gone back and forth on these things. But in this case, which you might have remembered started a few years ago with the Fisher case, what we had was that Ms. Fisher claimed that she'd been denied admission to the University of Texas because of her race. Texas has a provision called the Top 10% program, and essentially if you finish near the top of your class, you're guaranteed admission to a public university. And then they evaluate the rest of the student applicants on a basis of a number of criteria, including race and ethnicity. And that's pretty similar to what most colleges and universities do throughout the country. Well, the court rejected Fisher's challenge in a 4-3 decision and essentially gave a victory to supporters of affirmative action. Now, Justice Alito really went crazy. He actually said that this was affirmative action gone berserk. He read his dissent from the bench just to prove how upset he was about it. Justice Kagan couldn't vote because she had argued the case for the administration previously. So what did the ruling mean? Well, it means that universities can still consider factors like race and ethnicity when they're evaluating these other prospective students. So what you want to know for the bar is that if you have an affirmative action problem, you can still look at race and ethnicity as being qualifying factors. And that's really all you need to know about it. I mean, there's a lot of politics, there's a lot of up and down and back and forth between where this case was procedurally, but the reality is that that's where we stand today, that affirmative action is still constitutional. You know, could you see that in the bar? Yeah, I think you could. So, you know, did the examiners anticipate this result? Well, I doubt it, but nonetheless, there it is. So that's Fisher. It's so simple, isn't it? Okay. Don't you love the way I'm making this simple? Yeah, me too. Okay, the next decision or non-decision really is immigration. This is obviously a bigger question in the real world, I think, than it is in the bar exam world. But I want to talk about it only for a moment to say that in this situation, our lack of a ninth justice was significant. The court essentially came to a 4-4 tie on this immigration case in which President Obama had attempted to shield unauthorized immigrants who were parents of citizens or lawful permanent residents from being deported and providing them with work permits. And when the president introduced the plan, he essentially said to Congress, you know, go ahead and fight me on the issue. I'm going to take it as an executive action. And he said that, you know, that was perfectly within his rights as president. Well, a coalition of 26 states, led by Texas, Interesting how Texas keeps coming up, disagreed, and they challenged the plan. They said it ignored the procedures for changing rules administratively, and it was an abuse of power of the executive. A federal judge then shut the program down out of the Fifth Circuit, I believe, in New Orleans, and then it went to the Supreme Court. Now, the Supreme Court deadlocked in U.S. v. Texas, and the reality is, I think if Justice Scalia were still alive, he probably would have voted against this anyway. So I'm not sure we end up with a different result. However, because there's a stalemate, and this is the part I want you to know for the bar exam, when the court has a stalemate like this, a 4-4, which could happen even if you had 9 justices if one of them had to recuse themselves, in effect what happens is that the stalemate means that the underlying decision of the appellate court remains in place. Because the Fifth Circuit in New Orleans said that this action by the president was unconstitutional, it applies to the entire country now because the court couldn't reach a decision. Now, what makes this interesting is that there's a lot of thought that really a district court sitting in New Orleans probably shouldn't be making national law. And therefore, it's likely that a challenge will be raised in a more favorable circuit, like out on the West Coast, and we'll get a split between the circuits, and the case will come back, presumably when we have 9 justices, and we'll see again what happens. But for the moment, the holding stays in place. Nothing's changed. There's no precedent. It's just that holding remains in place, and that judge in the Fifth Circuit, or that panel of judges in the Fifth Circuit, essentially said, we're going to throw out this immigration decision. So I'd like you to know about it more for the procedural aspect than the outcome, because I don't think the examiners are testing the outcome of immigration in any particular way. So that couple of interesting decisions there. Well, I hope you're having as much fun as I am. And if you got comments or questions, be sure to let me know. I do want to make this interactive if I can. All right, couple of decisions then today that are interesting decisions, I think, and I want to just talk about those. Let's take first the decision regarding Bob McDonnell. He's the former governor of Virginia, and Governor McDonnell, ex-Governor McDonnell, was charged with using his office to help this guy, Johnny Williams, who had provided the governor with luxury products, loans, vacations. There was even some discussion that he was flirting with the governor's wife. I mean, it was really sordid. It was really fun to be in Richmond, Virginia when this was going on. In any event, the gifts that this Mr. Williams made were legal, but the question is whether or not they were part of a corrupt bargain in which the governor reciprocated by using the power of his office to help Mr. Williams. Now, what makes this case so absurd, factually, is that Mr. McDonnell was a completely ineffectual governor, and so he arranged meetings and attended events with Mr. Williams, who, by the way, made a very important product, a diet supplement. But they didn't have any success in obtaining support for his product in the Commonwealth of Virginia. And so the case went up to a jury in Richmond, and they found that Mr. McDonnell's actions, the governor, amounted to corruption, and a federal appeals court agreed. Well, last year, the Supreme Court intervened, kind of weirdly actually, to allow Mr. McDonnell to stay out of prison while they considered whether or not they were going to hear his case, which was McDonnell v. the United States. And that was an indication, I think, to most court watchers that they were going to go the direction they ultimately did. Now, what Mr. McDonnell's position was that relying on Citizens United, you remember the corporations are persons, the Supreme Court had said in that case that ingratiation and access are not corruption. Okay, I mean, I thought that was what the definition of corruption, but nonetheless, apparently it's not under Citizens United. And you might recall that same year, the court jumped in and ruled in favor of Jeffrey Skilling, the former Enron executive, saying that federal anti-corruption laws that governed honest services, though it's hard to imagine Mr. Skilling providing honest services, but it only applied to bribes and kickbacks, and there was no bribe or kickback here in McDonnell's situation. So there is something called the Hobbs Act, and the Hobbs Act says, in effect, that government officials are not allowed to take bribes and to be corrupt. I mean, essentially, that's the essence of it. And the claim was that the Hobbs Act would be unconstitutionally vague. Well, the court said here, they skirted all around that and said essentially, you know what, we just don't see any political bribery here. So what we're going to do is we're going to vacate the conviction of the former governor and we're going to send it back down for trial. My guess is that the Commonwealth won't prosecute again. But the essence of it is that we now have this basic ruling in this case that it is essentially harder to prosecute public officials for corruption. We've now got to see something, you know, the smoking gun in effect, in order to have a corruption case. So if you've got a potential public official and it looks like they're doing something that's a little underhanded, they're just giving some friendly access and help and you know, wise advice or something, that's not corruption. And that is no longer actionable. So I think what we've got here is that it's much easier to participate in graft and not be violating the law. And so there you go. Even if you're ineffective in your attempt to change the rules. Okay, next court, next case. I love this stuff. You know, you can't make this stuff up. The next case that came down today, actually, was the Texas abortion case. And you may have heard already today, or if you're listening to this later, you've heard about it. But essentially, there was a Texas law that would have reduced the number of abortion clinics in that state to about the number 10 from what was once about 40 clinics in the state. This was to me this was interesting on a lot of levels, but one of them is that Justice Breyer wrote this majority opinion, and we had, it was a decision 5-3. The Chief Justice, Justice Thomas, and Justice Alito dissented. That's not terribly surprising, I don't think. But the essence of the decision was that this Texas law that had imposed very strict requirements on abortion providers and it was set up presumably to help the safety of women, and required that the doctors had to have admitting privileges at a nearby hospital. And so what Justice Breyer wrote, interestingly, he said neither of the provisions in the bill offers medical benefits sufficient to justify the burdens upon access that each imposes. Each places a substantial obstacle in the path of women seeking a pre-viability abortion, constitutes an undue burden on abortion access, and violates the federal Constitution. And the justices went on to say that it would have caused about half of the state's abortion clinics to close. It would have left an area as large as California with no abortion clinics at all. I found it very interesting that one of the arguments was, hey, look, that's really not a problem because people in the west side of Texas could go to New Mexico for an abortion. That struck me as an interesting argument. But in any event, the court said, no, this is too much. Now, I think there will not be a question, I confidently predict there will not be a question on abortion because it's a trigger question. They're just not going to do that. But I do think what's interesting is to think about the analysis and the reasoning here that says you can't place a substantial obstacle in the path of someone who's trying to receive a federally mandated or a constitutional right. And that language, that reiteration of the language of the substantial obstacle, to me has real significance. I think we could see an expansion of that principle in a number of different areas. And that's what I'd be watching for, is anything that looks like the government is placing an obstacle in the path of someone trying to exercise their federal rights. So we'll see how that really goes and what it means specifically. But I think that while in this particular case it certainly upholds women's rights with respect to abortions, it's probably got greater implications, and on the bar exam its implication will be in the scope of the reasoning that's used in the case. So I know that people want to talk about this case for the politics of it. For the bar exam, I don't think you need to worry about that. I don't think that's where we're going. All right, now some other cases that were decided a little bit earlier in the term, but I think are worth talking about. Back in May, we had a case on jury selection. This was Foster v. Chapman. And the court decided in this case that prosecutors in Georgia violated the Constitution by systematically excluding blacks from a jury in a capital case, leaving an all-white panel to decide the fate of a black defendant accused of killing a white woman. I think this is a common sense decision. 7-1 suggests that it was pretty close. You know who the one was that was in the minority here. But essentially you cannot, what the rule is, and for the bar exam the rule is you can't systematically exclude a particular group or racial group from a jury, particularly in a capital case or specifically in a capital case. When you've got a black defendant, you cannot exclude black members of the jury. Let's see, what else do I want to talk about? Oh, voting rights, yes. Voting rights, which was an 8-0 decision decided back in April. This was Evanwell versus Abbott. And this was a case in which the court decided that states could draw voting districts based on total population under the one person, one vote principle. Now, the court had previously said for a long time that state voting districts had to have roughly equal populations, but they had never specified whether that meant the same number of people or the same number of eligible voters. I mean, there's clearly a difference between how many people live in an area and how many people actually vote. And the court here didn't address the question of whether states can draw districts based on voter eligible population. This was a method that obviously would have diminished the political power of districts that had a disproportionate number, for example, of unauthorized immigrants, and that might benefit Republicans. So the court basically said, you still have to use one person, one vote, and you can draw these districts based on total population, not the number of voters. So that was an interesting decision. We had another 4-4 tie having to do with public unions back in March. This was a case, Friedrichs versus the California Teachers Association. And this case, you might remember, it decided that public employees who chose to not join the union, the teachers union in this case, may be required to pay fees for the union's collective bargaining activities. Now, there wasn't a ninth justice, so we had a tie. That meant that, again, we affirmed the appeals court decision. In this case, the appeals court decision favored the union, said they could, in fact, require those fees, but it sets no precedent. So we've got the same situation that we've got when it comes to immigration. We just affirm the appeals court decision, and I suspect we'll see this one also challenged later in a different jurisdiction. We did have a case in class actions in a case that I cannot pronounce the name of the respondent. It's Tyson Foods. We're just going to leave it at that. And Tyson Foods, this case was brought by workers at a pork processing plant who said that they weren't getting enough overtime pay for the work that they spent putting on and taking off protective gear before they went into the plant. And the court decided that the workers can rely on a statistical formula to establish what they're owed, and they don't have to establish damages individually. Now, I don't expect you're going to get any case on class actions asking you about that specific fact pattern, but I do think it's interesting that the court essentially said here in a 6-2 decision that you can use a formula if it applies to the whole class, and you don't have to establish the damages individually when everyone's in the same situation. So that's kind of the rule to take out. We also had a capital sentencing decision which came from Florida in a case called Hurst v. Florida. Florida's capital punishment system is an interesting one. Essentially, the state allows non-unanimous juries to recommend death sentences and then leaves the final sentencing to the judge. Well, the court said in this case, in Hurst, that procedure did not give jurors a sufficient role in deciding whether defendants should be put to death, and so they overruled that procedure or policy in Florida. They made it unconstitutional, and now you do in fact have to give the jurors the decision and not the judge. So if you're in Florida, definitely want to know that one. I don't think beyond that in the rest of the country, yeah, you want to know that generally we're still saying that the juries have to make death sentence decisions when the case goes to the jury. Juvenile justice, since we're in the juvenile or in the Justice Department field, we had a 6-3 decision. This was back at the time that Justice Scalia was still on the bench, and the court ruled in Montgomery versus Louisiana that a prior decision banning mandatory life without parole sentences for juvenile killers had to be applied retroactively. which meant that there was a possibility of the eventual release for hundreds of inmates now serving life sentences without the possibility of parole for murders that they committed when they were juveniles. So that decision essentially took an earlier decision, just made it retroactive. So those are some of the decisions that have come about. I think those are most of the big ones. There was one other, there was a gun decision today, and in this gun decision, it essentially was a question of whether or not someone who had been a violation for shooting a bald eagle, which apparently was more serious than shooting at his ex-wife, whether or not he was entitled to continue to have his gun. The court said, you know what, we don't think he can keep his gun. I'm kind of thinking it was because of the bald eagle, actually, but nonetheless, that's what they decided. Again, what was notable about this case, and forgive me that I'm not coming up with off the top of my head the name of the case, but what was notable is this is the first time Justice Thomas actually asked questions from the bench in 10 years. He was interested in the Second Amendment aspects of the case. The court didn't go down the Second Amendment road. They didn't talk about the right to have a gun. They really just said, look, if you're a domestic violence, if you're creating and committing domestic violence and you've already been stopped on a federal gun charge, you're not entitled to go back and get another gun. Now, that's not gun control, it's just the reality of what's going on in that particular case. So, I think that is everything going on today. I think I've gotten through all of the decisions. Let me just make sure. I don't want to miss anything that might also be here. Right. So on this domestic violence case, that conviction is considered, the court said it was a misdemeanor crime of violence for purpose of limiting access to firearms. So that was the decision, and it's got a pretty narrow scope, I think. So again, I don't see it having a whole lot of impact. In general, on the bar exam, recent Supreme Court decisions are not going to have a lot of impact. I think I've touched on the things that could have some potential impact. If you happen to see a fact pattern that in some way is affected or seems to come into the range of what is in this term's decision, by all means talk about it, write about it, but don't obsess about it. The examiners didn't know about it, they weren't thinking about it when they wrote their question, and it's not going to be the determinant factor in their question. In the same way, on a multiple choice or the MBE, you are simply looking for the best of 4 answers. Even if it is now incorrect in light of a recent decision, if it is the best of the 4 answers, you still choose it. So I hope that helps. Well, glad to have you with me today. Hope that this was useful. I'm getting lots of positive feedback, lots of thumbs up and good stuff. Don't go crazy on this stuff. I mean, I like it. It's fun. It's intellectually interesting, but it's not something for you to spend a lot of time on, obviously. Just wanted you to know what's going on and have a sense of where we think it could impact on the bar exam. Look forward to talking to you all later, and thanks for sharing your time with me today. We'll say goodbye for now.